Namaskar. Good morning. This is further to our earlier discussions about Vidharbhapower case, where Supreme Court had given discretionary power to the adjudicating authority NCLT. The review petition, which was filed earlier by Axis Bank, was also considered by the Supreme Court, and it rejected Axis Bank's petition seeking reconsiderations of its earlier judgment that held that the NCLT, while examining the existence of debt and default by a corporate debtor on a financial creditor's plea for initiating corporate insolvency resolution process, has the discretion to admit or not to admit the plea. A bench comprising Justices Indira Banerjee and M.M. Sundaresh heard both the parties and refused to interfere with its earlier judgment. However, it clarified that the NCLT can exercise its discretion only under special circumstances. While seeking review of the judgment, the Axis Bank Council said that there was a need to revisit the verdict as IBC for the last 6 years had worked well. In the case Axis Bank versus Vidharbha Industries Power, the Apex Court had on July 12 held that Section 7(5)(a) of the IBC conferred a discretionary power on the adjudicating authority to admit an application for initiation of CIRP, and such power is required to be exercised with caution. It had differed from the long-settled view that the moment the NCLT was satisfied that a default has occurred, the application must be admitted unless it is incomplete. Until this order, the courts had held that the NCLT can only check for compliance and adherence to the legal framework and not interfere in the commercial aspect of negotiation or resolution. So, as on date, now the discretionary power with the adjudicating authority would continue, and if necessary, even if there is a default, they can always not admit the application and reject the application. Thank you.